Hi, everyone. My name is Amelia Phillips, and the big question today is, do employees who use medicinal marijuana have a reasonable expectation of privacy in their use of the drug, or are users required to disclose their use to their employer? So in short, an employee in Ontario is not generally required to disclose their use to their employer, their use of a disability-related drug like cannabis, although there are exceptions to that, for example, in safety-sensitive work environments. So I'll discuss that. So to kind of unpack the question, I have 3 topics that I'd like to chat with you about this morning. The first is the right to privacy and exceptions to that right. And under that topic, I'm going to touch on the Occupational Health and Safety Act. I'm also going to discuss disability accommodation in the workplace. And lastly, kind of highlight safety-sensitive workplaces and kind of discuss what that is, what it looks like. The second topic I wanted to discuss with you today is the duty to inquire, which impacts privacy rights of employees. And lastly, random drug tests. What are random drug tests and when are they allowable in this province and in Canada generally? So on to topic 1 then, which is worker right to privacy and the exceptions to that right. As I've mentioned, a worker has a reasonable expectation of privacy in their use of cannabis, and for a disability-related need. And there's no general law in Ontario for disclosure of their use of that drug. And that privacy protection, is in place because a worker might not want their employer to know about a sensitive medical condition that they have. They might also fear that disclosure of their use of the drug, even for medicinal and disability-related reasons, might hinder their opportunities at work or hinder their opportunities to advance in the organization. And they also might wonder whether the perception of them at work will change. Will their employer question their ability to perform their duties at work? And will their employer see them differently? So that's, these are the source of reasons why there is a right to privacy in the use of medicinal cannabis. And the Ontario Human Rights Tribunal has a policy related to the use of cannabis and the Human Rights Code, medicinal cannabis and the Human Rights Code. And that policy states that workplace policies or employer policies that automatically discipline employees for not coming forward and disclosing disability-related cannabis use or cannabis addiction may be discriminatory. However, there are exceptions. Arguably, workers have a duty to disclose under the Occupational Health and Safety Act. This act, an Ontario Act, states that a worker must report to his or her employer the existence of any hazard of which he or she knows involving the workplace. So this requirement under the Occupational Health and Safety Act is particularly relevant in safety-sensitive work environments. So, for example, on a construction site where heavy machinery is being used, and the misuse of that machinery could result in catastrophic injury or even death, the Occupational Health and Safety Act suggests that a worker must report to his employer that he or he's using medical marijuana if it might affect or affect the safety of the workplace or present a hazard in the workplace. Also, I wanted to chat about accommodation in the workplace. Failure to disclose medicinal cannabis use may relieve employers of their duty to accommodate. Under the Ontario Human Rights Code, employers have a legal duty to accommodate the disability-related needs of their workers, their employees, who use cannabis for a medical purpose or are addicted to the drug. So employees, in other words, have a right to disability-related accommodation of their condition and to the point of undue hardship to the employer. So undue hardship can be something like, significant health and safety risks in the workplace, or excessive costs to the employer if that employee were to be accommodated. And people seeking accommodation. So if I were to backtrack, the undue hardship level that's required, the level that's required to meet undue hardship is rather high. So accommodation at work for, the disability-related needs or disability-related needs associated with cannabis use is a strong right. So if a person wanted to take advantage of accommodation at work, they would be required to provide medical or other information to support their need for accommodation. So that's kind of where the privacy right is affected. But necessarily, in order for your employer or for the employer to accommodate the employee at work. The Ontario Human Rights Commission has set out the types of information that an employer can and cannot ask for when it comes to accommodation or in the accommodation context. So it's pretty clear on the kinds of information that an employee should give, is required to give if they want to be accommodated at work. So I'll go through a bit of that. I think it's important to kind of know what information an employer is entitled to have in order to accommodate an employee who is using cannabis medically. So an employer can ask for or is entitled to information that the person in question has a disability. So not what the disability is, but that there is a disability. The employer is entitled to that information, as well as the limitations or needs associated with the disability, whether the person can perform the essential duties or the essential requirements of their job while using the drug, with or without accommodation. The type of accommodation that is needed to allow the employee to fulfill the essential duties or requirements of their job. So that's some guidance on what kind of work they are able to do. And their employers are also entitled to regular updates about when that person or employee expects to return to work as usual. But where more information about an employee's disability is required, the information requested has to be the least intrusive of that person's privacy, while still giving the employer enough information to make a sensible accommodation for them. So information that an employer cannot ask for would include generally information related to the cause of their disability, what the disability is or the diagnosis, what the symptoms of their disability are. That sort of confidential medical information is not generally required to accommodate an employee at work. In rare situations, Where a person's accommodation needs are complicated, of course, there might be more information that is needed by the employer in order to accommodate that person. You know, that person may be required to cooperate with providing that information in order to be accommodated in the workplace. However, wherever possible, of course, an employer should make genuine efforts to accommodate their employee without requiring information that is not absolutely necessary. Okay, and you know, at this point, I'd like to talk to you about the safety-sensitive workplace and what that's like. Safety-sensitive workplaces vary, but some examples that I can give you are, and one I gave you already is, you know, the example of the construction site where heavy machinery is being used, and the misuse of that machinery could result in catastrophic injury, either to the employee or their colleagues or people in and around the job site. Another example is, you know, if you work in transportation, a driver of a bus or a train conductor, or anyone involved in, you know, the operations around transportation, or individuals that are working with environmentally sensitive products, chemicals, or explosives. These are, you know, examples of a safety-sensitive job. And I want to give you, you know, a real-life example as well, a recent case that was decided by the Human Rights Tribunal last year. It demonstrates, you know, that there is a duty to disclose medicinal cannabis use in the context of a safety-sensitive job. So in this case, there was a painter, and he worked about 37 floors above ground outside of a building. And he smoked cannabis for a medicinal purpose at work during his breaks. He ended up being terminated for doing so. And the Human Rights Tribunal agreed with the employer that, you know, he was rightfully terminated in this case. And it wasn't discrimination for him to be terminated, even though he had a disability-related need to smoke cannabis. And I'll tell you why. The Human Rights Tribunal found that his termination wasn't discrimination because, one, his actions represented a genuine health and safety risk, given the safety-sensitive nature of his job and the safety-sensitive nature of the job site. And two, there was no evidence that the employee ever asked for an accommodation. He never gave any information to his employer about his need to use medicinal cannabis throughout the day. Instead, the painter had taken it upon himself to smoke during the day at work without you know, any instructions from his treating physician to do so, or authorization from his treating physician, or any authorization from his employer. And the HRTO also found in that case that the employer's policy, the employer had a policy prohibiting, you know, cannabis smoking on the job, which many employers do have, and should have. We can discuss that as well. The HRTO has found in this case that the employer's policy prohibiting cannabis smoking on the job was reasonable, and importantly, did not close the door to accommodating employees by moving them into safety or non-safety, by moving them into non-safety sensitive jobs. So in this case, with the painter, perhaps he could have been moved inside to do work. Perhaps he could have been moved to a ground floor. Perhaps he could have been moved into an administrative or you know, clerical position. But none of those options were available or to be canvassed by the employer because they didn't know. They didn't know that he needed this accommodation. He simply kind of took it upon himself to medicate at work without informing his employer and without authorization from his doctor. And I want to just underscore the authorization from his doctor point as well, because that reminds me of an important issue, which is that, you know, a doctor that is writing up a note, for example, about cannabis use requirement on the part of an employee, really should know what the employee does, the kind of work that the employee does, and in particular, if the employee works in a safety-sensitive job. Now, I'd add to that example with the painter, excuse me. I'd add to that example with the painter that employers have an obligation to exercise due diligence in mitigating workplace health and safety risks. This is not an option, but rather employers are legally obligated to minimize the risks caused by employees who are impaired by cannabis at work. This is under the Occupational Health and Safety Act, which imposes a duty on employers to take every precaution reasonable in the circumstances to protect workers on the job site and those in and around the job site. Okay, so that concludes kind of discussing, you know, in brief, the privacy right with respect to medicinal cannabis use and the exceptions that exist, in particular in safety-sensitive job environments. And I want to move now to briefly discussing the second topic, which is the employer's duty to inquire. Employers, this is important, you know, employers have a legal duty to inquire where an employee is clearly unwell or is known to have or is perceived to have disability needs related to cannabis use for a medical purpose or related to cannabis addiction. So in a nutshell, this is a duty to ask the employee about their use in order to accommodate them. When you suspect as an employer that they have a problem, and you know that they need an accommodation but haven't asked for the accommodation. So this is really going, you know, the duty to inquire really gives the employer some help and control in inquiring into suspected abuse of drugs at work. But also it shows that the employer is kind of given this responsibility to help their employee if they suspect that they might have a problem or need an accommodation. So in this context, an employer is not only allowed to ask questions about medicinal cannabis use or addiction, but has a duty, in fact, to ask if an employee may need help. So that duty to inquire is something I find particularly interesting, and it can be pretty nuanced depending on the fact situation that you're dealing with at your at that job or in your workplace or organization. Happy to take questions not only now with respect to this, but also afterward. Happy to take questions via email. But before that, I want to move to the third topic that I want to chat with you about, which is, again, briefly, that's drug testing. So generally, employers cannot submit employees to random drug tests, not only in Ontario, but across Canada. And this is the case because of the potential to intrude on a person's privacy. Because of that potential, it's pretty high, it's pretty intrusive. Drug and alcohol testing can only be justified in very narrow circumstances. So I'll tell you, give you an example. So where there are health and safety concerns, I mean, this is, I want to tell you when a random drug test might be acceptable. in this country. And again, it's very, very difficult test to pass, but where there is a genuine health and safety concern involving a dangerous workplace or a dangerous work environment in which people are doing safety sensitive work. So what we've been discussing, but not only that, there's another requirement. So there's a safety sensitive job. And in addition, there's evidence of a problem with drugs in that workplace. So there's an added feature for random drug tests to potentially be passable legally. There is a safety sensitive work environment in addition to a demonstrated problem in that work environment with employees abusing drugs. So to underscore what I said, drug and alcohol testing that has no demonstrated relationship to job safety, or where there is no evidence of enhanced safety risks in that particular workplace, has been found to violate employees' rights, including their privacy rights. Okay, so I think we're moving on to questions. So if you, I know we have a couple of questions here, and you can continue to send them in. So if you want to send in a question, and perhaps I should have said this at the beginning, I'm not sure, but I will tell you now that if you want to send us questions, you can by emailing us right now at socialmedia@macdonaldassociates.ca. So social media at MacDonald, MacDonald Associates with an S .ca. And there is also a Q&A app to the right of your screen if you are logged into Google that you can use. So feel free to, if you have any extra questions, but we do have some here. So the first question I have here is, what is the difference between cannabis addiction and cannabis medication? Okay, so cannabis addiction and medicinal cannabis. So if an employee is using cannabis because they're addicted, or they're using cannabis because it's medically necessary, they're often treated the same. So the two are often interchangeably used, and I've done that a little bit throughout this session today. Drug addiction is treated as a disability under human rights legislation. So it is just like using prescription drugs for, including cannabis, for a disability-related need. So in the context of privacy, if there is an addiction issue and a worker wants to be accommodated for that addiction issue, they will need to provide information to their employer about their addiction in order to be accommodated. And addiction, I guess, one of the nuances of addiction is that the employee might not have any control over their use of the drug. So whether if they might be compelled to use it during while they're on the job, but it is seen as a disability, and so it ought to be accommodated. But in order for accommodation to attach, that employee does need to reveal that they need an accommodation and they have this disability. So in a nutshell, drug addiction is treated a lot the same with respect to privacy rights as medicinal cannabis use. Okay, so another question we have is, can an employer require disclosure of cannabis use? I'm going to this doesn't say medicinal, but we're discussing medicinal. So can an employer require disclosure of medicinal cannabis use in order to ensure there is no decreased performance or inappropriate behavior in the workplace? So the short answer to that would be no, they can't. As I've discussed, the safety sensitive workplace is an exception where an employer can kind of compel or require disclosure under case law as well, common law, case law, or under legislation like the Occupational Health and Safety Act. But an employer cannot compel disclosure or require disclosure of medicinal cannabis use because they wish to increase performance at the workplace, or they want to avoid inappropriate behavior by an employee at the workplace. That doesn't meet the bar. It doesn't meet the standard required in order to kind of intrude on personal privacy rights. And I know I just recently gave an email address, so I'm just going to see if there are any questions that came through. So I have a question here. Is it possible for employers to take a course on how to be compliant on cannabis use in the workplace? And certainly there are courses that employers should take courses. We actually offer workshops for our employer clients, and happy to offer and bring together our clients for another workshop on the issue of addiction in the workplace and drug and alcohol use in the workplace or by employees. So certainly possible. I know that it's actually a hot topic right now with cannabis use, recreational cannabis use being legalized in the province last year. And so please email us, and we'd love to give a crash course for sure on the ins and outs of this, because there are a lot of nuances, and it's really great to kind of get specific examples of what's happening in your workplace so that we can kind of address the specifics of what's happening for you. So 100% there are, and we can help with that. Another question I have here is, what about employees doing cannabis off the job, but there are continuing effects? Okay, so that's also a great question. So I should clarify, it's a very important question. So what we're dealing with is impairment. So it's not so much, it of course is the smoking of the drug, but in the resulting impairment that's caused by the marijuana use is what attracts the legal attention. So I know that there's I had written down a number of effects that marijuana use can have. So for example, decreased motor function, or feelings of paranoia, or diminished cognitive function, or confusion, or difficulty concentrating, as some of the the established effects of cannabis use. So if those effects are still continuing while a worker's on the job, then 100% an employer can still has all of the duties I've discussed, and employees have all of the duties that I've discussed here today. So even if you're off, or an employee's off-site, off-duty use of the drug is impacting them while they're at work, so if the effect of the drug is still in their system, still affecting them when they get to work, it's a live issue, and all of the things I've discussed apply. So thank you for that question. And barring any other updated questions that come through, I don't think we have any others. That is it for me this morning. Thank you for joining us. I wanted to let you know as well that if you'd like to suggest a topic for us to discuss, or for me to discuss in the future, please email us at socialmedia@mcdonaldsassociates.ca. That's social media at mcdonaldsassociates.ca, and we will be happy to address those issues or whatever the issues are that you have. And again, thanks for joining us.